Am I able to record? I think I'm able to record this. All right, I'm recording now. Okay. Ready? Make sure that you unmute your microphones, or let me just do it real quick myself. Okay, here we go. This discovery deposition and the video deposition for use at trial noticed or to be noticed by plaintiff's counsel for the same date and time are proceeding as a courtesy to plaintiff based on representations that plaintiff is in poor health and that exigent circumstances exist. This deposition has been scheduled and noticed in accordance with and in full reliance upon the understanding that it is agreed that attendance or participation at the deposition by any defendant or by any counsel on behalf of any defendant shall not be deemed an entry of appearance, or serve as acknowledgment and or acceptance of process, and such attendance or participation shall not constitute a waiver of any defense, argument, or position, legal, factual, technical, substantive, procedural, or otherwise, that any defendant may desire to or be entitled to assert. In the event plaintiff or any other party intends to oppose, contest, or otherwise disagree with this prerequisite understanding, a formal objection to this notice is expected and demanded. Take a deep breath. Let's do it again, a little faster. Ready? This discovery deposition and the video deposition for use at trial noticed or to be noticed by plaintiff's counsel for the same date and time are proceeding as a courtesy to plaintiff based on representations that plaintiff is in poor health and that exigent circumstances exist. This deposition has been scheduled and noticed in accordance with and in full reliance upon the understanding that it is agreed that attendance or participation at the deposition by any defendant or by any counsel on behalf of any defendant shall not be deemed an entry of appearance or serve as acknowledgment and or acceptance of process, and such attendance or participation shall not constitute a waiver of any defense, argument, or position, legal, factual, technical, substantive, procedural, or otherwise, that any defendant may desire to or be entitled to assert. In the event plaintiff or any other party intends to oppose, contest, or otherwise disagree with this prerequisite understanding, a formal objection to this notice is expected and demanded. Again, take a deep breath. Ready. This discovery deposition and the video deposition for use at trial noticed or to be noticed by plaintiff's counsel for the same date and time are proceeding as a courtesy to plaintiff based on representations that plaintiff is in poor health and that exigent circumstances exist. This deposition has been scheduled and noticed in accordance with and in full reliance upon the understanding that it is agreed that attendance or participation at the deposition by any defendant or by any counsel on behalf of any defendant shall not be deemed an entry of appearance or serve as acknowledgment and or acceptance of process, and such attendance or participation shall not constitute a waiver of any defense, argument, or position, legal, factual, technical, substantive, procedural, or otherwise, that any defendant may desire to or be entitled to assert. In the event plaintiff or any other party intends to oppose, contest, or otherwise disagree with this prerequisite understanding, a formal objection to this notice is expected and demanded. This discovery deposition will commence at the conclusion of plaintiff's direct testimony on video deposition as noticed or to be noticed by plaintiff's counsel, but before defendants complete the video deposition by conducting any desired cross-examination of plaintiff thereon. Alternatively, this discovery deposition will commence before the plaintiff's direct testimony on video deposition and will conclude before or may be interrupted by the plaintiff's direct testimony on video deposition as may be agreed to by counsel. This discovery deposition will be recorded by stenographic means. Again, for accuracy. Ready? Check it out. This discovery deposition and the video deposition for use at trial noticed or to be noticed by plaintiff's counsel for the same date and time are proceeding as a courtesy to plaintiff based on representations that plaintiff is in poor health and that exigent circumstances exist. This deposition has been scheduled and noticed in accordance with and in full reliance upon the understanding that it is agreed that attendance or participation at the deposition by any defendant or by any counsel on behalf of any defendant shall not be deemed an entry of appearance or serve as acknowledgment and or acceptance of process, and such attendance or participation shall not constitute a waiver of any defense, argument, or position, legal, factual, technical, substantive, procedural, or otherwise, that any defendant may desire to or be entitled to assert in the event plaintiff or any other party intends to oppose, contest, or otherwise disagree with the prerequisite understanding. A formal objection to this notice is expected and demanded. This discovery deposition will commence at the conclusion of plaintiff's direct testimony on video deposition as noticed or to be noticed by plaintiff's counsel, but before defendants complete the video deposition by conducting any desired cross-examination of plaintiff thereon. Alternatively, this discovery deposition will commence before the plaintiff's direct testimony on video deposition and will conclude before or may be interrupted by the plaintiff's direct testimony on video deposition as may be agreed to by counsel. This discovery deposition will be recorded by stenographic means. Okay. Read it back. Since Jade is the new person to the group, she gets to go first.
Yay! Yay, Jade!
Go, Jade!
So is this a I read back and everybody's nice and it helps when I screw up kind of thing?
It is.
Great. Okay.
You get to read the first long sentence, and then I'll switch it out to somebody else. We kind of rotate.
This discovery deposition in the video deposition for use at trial, notice or to be noticed by plaintiff's counsel for the same date and time are proceeding as a courtesy to plaintiff based on representations that plaintiff is in poor health and that I know I skipped something, and that circumstances exist. I know I skipped.
Exigent.
Yeah, that I skipped that word.
Oh, so you made one mistake on that whole sentence. Oh, that's impressive. Very good.
Oh, thank you.
Very good. Okay, next, Hannah.
This deposition has been asked and
scheduled
and noticed in accordance with and in
what's your steno?
FU.
Full reliance.
And I have the understand.
Full reliance upon the understanding
that it is agreed that attendance for Dictation,
PAR,
participation
participation, good.
at the deposition by any defendant or by any counsel on behalf of any defendant shall not be deemed an entry.
Deemed an entry of
Entry of
APZ, ARPZ, anything like that?
I have
Appearance,
PAERNT, apparent,
appearance,
or serve as knowledge, as acknowledgement, or
and or
and or I have ants,
acceptance,
acceptance of proceeding and
process.
process and such a, let's see, and
Attendance,
attendance or
PARPGS,
PGG, yeah,
participation,
participation,
shall no,
shall not something, a waiver,
constitute.
constitute a waiver of any defense,
Okay, stop right there.
argument.
Okay, any defense, comma, and then we'll let Lisa pick up.
Okay, argument or position, legal, factual, technical, substantive, procedural, or otherwise, that any defendant may desire to or be entitled to a oh gosh, I have a CRT.
Yeah, you almost got it. Assert.
Oh, assert. Oh gosh. In any event.
In the event.
Oh, in the event, plaintiff or any other part.
Party.
Other party intends to prove, contest, or
Oppose.
Otherwise.
Oppose, contest.
Oh. Geez, okay. Oppose, contest. I'm sorry, I know I got the background noise.
That's all right.
Too going on. Or otherwise disagree with the requisite.
With this prerequisite.
Understanding a formal.
Mm-hmm.
No. Okay. Objection to this notice is expected and demanded.
Good. Okay. Jade.
Okay. This discovery deposition will commence at the something of plaintiff's direct testimony. At the conclusion?
Conclusion.
Okay, at the conclusion of plaintiff's direct testimony on video deposition as noted, or as noticed, or to be noticed by plaintiff's counsel, but before defendants complete the video deposition by conducting any desired, did I skip a word somewhere in there?
No, you're good.
Okay, by conducting any desired cross-examination of plaintiff thereon.
All right.
Alternatively, okay, sorry.
Next.
Alternatively, this discovery deposition will commence before the plaintiff's direct testimony on video deposition and will conclude before or may be interrupted by the plaintiff's direct testimony on video deposition as may be
What's your steno?
E.R. Longview directed.
Agreed?
E.R. Oh, agreed. That's part of G. To my counsel.
By counsel.
By counsel.
Okay, next. One sentence. Lisa?
Sorry.
That's okay.
I had to tell the kids to keep it down. Okay, this discovery deposition will be recorded by stenographic means.
Great. Good job.
I have a quick question.
Sure.
The sentence before where it says, by the plaintiff's direct testimony on video deposition as may be agreed, that would be may be 2 words instead of maybe, right?
Yes. Maybe
Okay.
2 words.
Okay. I just wanted to make sure. Thank you.
This legal stuff, this, the commas, the punctuation, the apostrophe, all that stuff is just, it's a nightmare. It's a nightmare to write. It's a nightmare to transcribe.
Mm-hmm.
It's like, where does that comma go again? So it can be rather crazy. Let's do one more section, and then I think y'all did this before, and I'm going to do it again. Jade missed out on this other verbal abuse, and so we'll share it with her. So I'm gonna mute y'all for now, and hang on one second. Shake it out, relax, deep breath, be focused, and just write. Here we go. Ready? Certain standard stipulations shall be in effect for this discovery deposition as follows. 1. An objection by or on behalf of one party shall be deemed an objection for all parties present. 2. With the exception of objections as to the form of a question, all objections are preserved for the record and need not be noted. Any objection as to the form of a question should be expressly noted for the record, but the specific grounds for the perceived form issue need not be stated unless requested by a party. Deuces tecum. Plaintiff is directed to produce any of the following materials not previously produced at least 2 full business days before the deposition. This notice is absolutely contingent on such production, and the deposition may be canceled if such materials are not timely produced prior to the commencement of the deposition. 1. Any photo, chart, drawing, illustration, map, plan, or other such item that plaintiff intends to discuss or rely on for any reason and or in any way at the deposition. 2. Any materials studied, reviewed, consulted, referred to, or in any way directly or indirectly relied upon in providing information used in responding to written discovery requests in this litigation. 3. Any documents or other materials indicating, referring to, referencing, or discussing any current medical condition or ailment and or any medical condition or ailment allegedly related to exposure to asbestos. 4. Any documents or other materials indicating, referring to, referencing, or discussing any aspect of plaintiff's work history, including, but not limited to, lists of employers, places of employment, dates of employment, etc. 5. If an economic loss claim is asserted, copies of federal income tax returns and supporting documentation as filed for the preceding 3 tax years, as well as pension, disability, and or retirement benefit award documentation. Let's read it back. And Jade gets to go first.
Awful. Oh my gosh. Okay. Certain standard stipulations shall be in effect for this discovery deposition as follows.
Stop.
1.
Who's next? I'm going to be brutal. Hannah.
Okay, I'm still
Boys.
scrolling up. Give me just a second.
Dogs, be quiet. No barking.
Okay, we're at 1. Okay.
Yeah, number 1.
1, an objection by or on behalf of one party shall be deemed
Deemed.
an objection for either parties
For all parties
present.
present. Okay. And, Lisa?
2, with the exception of,
You're good?
is that right? Exception? Okay, of objections as to the form of a question. All objections are preserved for the record and need not be noted. Any objection as to the form of a question should be expressly noted for the record, but the specific grounds
Specific grounds?
for the perceived form issue need not be stated unless requested by a party.
Okay. Do y'all know what that means, those two things at all? Does that make sense to y'all?
I'd have to reread it to get I'm just looking at word by word, Let me see.
I'll read it to you, and a lot of times it helps when you kind of understand what the heck is going on instead of, you're just focusing on the words. But they say an objection by or on behalf of one party shall be deemed an objection for all parties. This is a large case with multiple defendants. So, hang on one second. Okay, I had to mute Lisa. I was getting an echo. So what that means is if one defendant objects to a question asked, that means that that objection can stand for all the other defendants. And so if you have like a case that has a lot of defendants, instead of having each of the defendants go down the list and say, I object to the question, and the defense attorney too, I object to the question, and the third, fourth, fifth, however many's in there. In this case, I think it was an asbestos deposition with, multiple attorneys. You could have 20 objections before the witness gets to even answer. And so what they do is they'll have one defense attorney make the objection for all that want to join in later. So that's what that means. And then on the second one, it says, with the exception of objections as to form of a question, all objections are preserved for the record and need not be noted. What that means is, like in Texas, we just have objections to the form and the non-responsive or the responsiveness of the answer. So an attorney can ask a question, and the defense attorney or plaintiff, whoever's objecting, can just say, object to the form of the question. And they'll discuss it later in court. They don't have to go through all the diatribe like they used to do back years ago, where they would have speaking objections that could go on for a page or longer and argue about it. And the only exception to that is they later say in this thing, any objection as to the form of a question should be expressly noted for the record, but the specific grounds for the form issue need not be stated unless requested. And that means that the attorney can object to form, and if the other side wants clarification, then they can discuss it and hash it out. Otherwise, they just object to the form, and then later they'll come to the judge and say, my form objection was because the question was vague, or it called for facts not in evidence, or called for speculation or whatever. So let me unmute y'all. And does that make sense what I explained?
Yes.
I'm assuming
Yeah.
that's like when I was doing my internship, and a lot of the times the other attorney would just say objection form, and the witness would look at him like, what do you mean? And he's like, just keep going. Don't worry about it.
That's
So
exactly
you're
what that
saying
means.
just for the fact that he's noting, yes, I'm objecting, but you guys can still answer the question.
Right. And then
Okay.
what will happen is they'll come into court, if it goes to trial, the attorneys can bring up those questions to the judge before they're played to the jury and get those hashed out. That way you don't have unnecessary testimony cluttering up the record, so to speak, for the jury to have to muddle through or have to listen to. The judge and the attorneys, either before trial even starts or a week or a day or two before trial, they'll do that and get it hashed out so that they have a clean deposition to read to the jury or have it taken care of ahead of time. And then y'all know what the deuces take 'em is. That means to bring documents to the deposition, and the attorney is listing here. They want 5 things with apparently subparts because it's like any photo, chart, drawing, illustration, map, plan, etc., etc. Um, they want all these things produced ahead of time because in civil cases, the both parties get to know what the other side's case is about basically before trial. Criminal is not like that. The defense attorneys in a criminal case have to show nothing to the state or the government for the most part. But in in civil cases, they produce the documents, they produce the police reports, they produce the charts that they're going to use, or blah, blah, blah. So that's what that stands for, or what that means. So who wants to pick up with Deuces Take 'em?
I have to find where we're at.
Oh, tell me that y'all were writing everything I was saying just now, right? Yeah, I know. Okay,
Are we on plaintiff is directed to produce?
that's
Is
it.
that where we're at?
Start there. Uh-huh.
Okay. Plaintiff is directed to produce any of the following materials not previously listed.
Produced.
Reduced.
Not previously produced at least 2.
Okay, yeah, not previously produced at least 2 full business days before the deposition.
Mm-hmm.
Okay, I just wasn't saying it in the right way. This notice is absolutely contingent on such, I think I dropped a word, on such something.
What's your next stroke? What does it look like?
Well, I know that I dropped it because then the next thing is and the deposition.
Okay. On such production and the deposition.
And the deposition may be canceled in such,
Canceled.
no, if such,
If such.
such materials are not produced prior to,
Timely produced.
timely produced prior to the commencement of the deposition.
Okay, good. Next, let's see, who hasn't, who read that? Hannah?
Let's see. I have any photo. Is that right? Any photo, chart, drawing, illustration, map, plan, or other such item that plaintiff intended to discuss.
Intends.
Intends to discuss or rely on for any reason or in any way for the deposition.
In any way.
And or in any way for the deposition.
At the deposition. Okay. Number 2, who's next?
I guess me.
Yes.
Okay. To any materials studied, reviewed, consulted, referred to, or in any way directly or indirectly relied on and providing, upon.
Relied upon in.
Okay. Is it providing information used in, oh gosh, I have prong, I don't know what that is.
Responding?
Oh gosh, okay, responding to written discovery request
Mm-hmm.
in this litigation.
Mm-hmm. Good. Jade.
Any documents or other materials I don't know what this is.
What's the stroke?
I have encrated. That's not a word.
Indicating?
Indicating. Oh, it's because I added that R. Indicating, referring to, referencing, or discussing any current medical condition or ailment, and or any medical condition or ailment allegedly related to exposure to asbestos.
Great.
Oh, okay.
Good job. Next, number 4.
Or any documents or other material something referring to reference.
Okay. How do y'all write the word indicating?
Apparently I do K-A-E-T.
Yeah, that's what I do too.
Yeah.
K-A-E-T? Okay.
Yeah. Indicating, referring to, referencing, or discussing any aspect of plaintiff's work history, including but not limited to his employers,
Lists?
list of employers, place of employment,
Places of employment.
places of employment, dates of employment, 5 minutes,
etc. Yeah. Okay, next, number 5.
5, if an economic loss is
Economic
claimed.
loss claim is
Oh, okay, that was all stacked. Inserted.
is asserted.
Oh, geez.
That's okay. How do you do asserted? How do
I
I
don't
write
even
that?
know. I think I probably write it out. I put inserted, so I had S-N-E-R.
Okay. All right.
So,
If an economic loss claim is asserted, comma.
is it copies of federal
Uh-huh.
income returns and
Tax
supporting?
returns.
Oh,
That's okay.
okay. And supporting documents as filed for
Documentation. This is a tough one.
Really?
Yeah.
Oh God, this is so embarrassing. For the I have PROED and then I have tax years.
Preceding 3 tax.
Years as well as pension, disability, and or is
Disability
it retirement benefit?
or other retirement.
We're jumping on the plane.
Benefit or
Award.
awarded documentation.
Award documentation.
Okay.
It's or other retirement
man.
benefit award documentation. All right.
What is a brief for etc.?
I do ETS, etc. That's how I hit that.
Ooh. What if my ETS is ET, like the abbreviation for etc.?
You
Is
could
that how
do
you actually write it out?
ETC. You could
Would
do
be your written out one?
asterisk ETC, asterisk ETS to
Okay.
to shorten it, and to
Okay.
run it out ETS without the asterisk to get the et cetera in 2 words.
Okay.
Yeah. So, all right. I think with that, I'll stop for today. Like I said, it was kind of spur of the moment, but I had some time, so I thought I'd do it real quick. Did y'all enjoy that?
Yes.
Yes. And I
Is
know as painful as it is to read back sometimes, I know Jade and I go to school online, so making someone kind of force us to read back, I think helps so much.
we uh, we did that with a group that we were dictating to. Just went down the list and made them all read back, and
Yeah.
it was fun.
It's a very, very, very scary thing
Yeah,
that nobody wants to do, but I guess, I mean, obviously we're going to have to do it, so I'd rather
yeah.
mess up in front of you guys than mess up in front of some attorneys.
I couldn't think of the word that Karen had said earlier, but it's X-ray your notes. I'll X-ray your notes, and I'm pretty good about being able to pick apart your notes and not even see them. But I can, if you'll tell me what's around your strokes, I can kind of help you figure out what you're doing. Like earlier, there was something about the word production, but oh, such production. Remember, and I think one of y'all had drugged the S into the production, so it was SPRU something.
Right.
So, it was trying to show you what your tendencies are as far as misstroking. And, I can, I've been lucky about being able to do that and kind of x-ray your notes, so to speak, and dissect them and help you. Autopsy, that was it. Autopsy the notes. That's what she called it. Autopsy the notes.
Yeah,
So,
this is great. I need to make myself do it more because it really is just very, very scary, but I've got to make myself do it.
yeah, it's good practice. It's good to make you read back instead of just sitting there and writing. And you may think you got it, and then when you go back and look at it, and you're like, oh my God. And then other times you think, I didn't write very good on this, and you go back and read it, and you got more than you thought you did. So
Yeah.
kind of forces you to be honest with yourself, and it teaches you to read uh, your bad stuff because you don't write everything perfect all the time. You're going to drag a letter here, but you need to learn what your tendencies are. And if you never look at your notes, you'll never know. So
I agree.
I did
And
record this
definitely
session.
is.
I'm sorry.
Oh, I was just saying, with this, I think the coolest part is being able to say, "Hey, I can read some of my sloppy stuff."
Yeah. And the thing is, you make it fun with everybody around you so that, if you have a bad day, that's okay. Nobody's criticizing. And sometimes it's fun. But it gives you a chance to see that I'm not the only one in this boat that's having a hard time, you know.
Yeah.
Right.
So that last section, when we started doing this last dictation again, where I kind of started over with this discovery deposition and the video deposition, blah, 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 I started recording it right there. I can save it, I can publish it for others to follow along with us, or I can delete it, and it's up to y'all. It's your pleasure.
I mean, I wouldn't mind you posting it just to even go back myself and be able to, look at
Yeah.
it. I'm just
Okay.
saying I personally don't care if people hear, me pausing and messing up.
Okay.
So.
And I
I'm like Jade. I don't care either. It's fine.
don't care
Okay.
either.
Okay. Good. Let me stop the recording here, and I'll hang on and we'll talk some more. So I'm going to do that real quick.